Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today's guests are Howard M. Erichson, the Maria L. Marcus Distinguished Research Scholar and Professor of Law at Fordham Law, and Maria Glover, Professor of Law at Georgetown Law. Welcome, Howie and Maria.
Thanks so much for having us.
Thanks. Good to see you.
Well, delighted that you're here and that we are going to be exploring the topic of civil procedure, which I know that you can make sound a lot more fascinating than many. Let's start by just looking at legal education, and you're explaining how civil procedure fits into a student's legal education. What role should it play in the curriculum? Howie?
Yeah, so this is the course that lets students understand that process matters. You know, when you think about a law student arriving in law school, for the most part, they're learning all about substantive law. They're learning torts, contracts, property, even substantive criminal law. But they need to understand that those substantive rights and duties don't mean anything unless there are procedures that can turn them into a reality. And that's where civil procedure comes in. It's really, for students, I think, the first time they're thinking seriously about this connection between law and facts substantively on the one hand and process on the other hand as coming together in a system of justice. So to me, that's the heart of it, is students need to understand that process is just as important as the substantive rights that the law provides. And then where it fits into the curriculum more broadly is for 1L students, civil procedure is kind of a service course, that to understand how to read cases in all their other courses, students need to learn a thing or two about the civil litigation process. Then the last thing I'll mention is, you want students to come to law school and to start right away thinking about justice. Yeah, and there are a lot of ways to think about justice, and there are different notions of what justice is. But I would say civil procedure is the course in the 1L curriculum where students think most explicitly about our system of justice, about access to justice, about fairness, about differential resources, and how procedure can exacerbate those problems or alleviate those problems.
And Maria, that was a great answer. Howie, you make me think back more fondly about my civil procedure experience, because I didn't think about it at the time as this kind of access to justice oriented course. And how do you, Maria, get students to see it that way, that it's not the dreaded, rules-based course that we just got to memorize a lot of these different rules? How do you encourage this idea that this is the threshold really to justice in our system?
So I do this in a few ways, and Howie and I tease this out in our book. We start with a concrete case example, a relatively simple, maybe it's not slip and fall, but a gentleman who injured himself in a small ravine near his hotel, and he sues the hotel for damages. And we walk through the entire litigation process and see what it takes, right, for him to even bring the claim, for that claim to survive initial review, for him to get the sort of information that he might need, and for the hotel to get the information it might need to come to some sort of understanding of who's at fault and who's liable and is anyone liable. And we follow that case all the way through trial and appeal. And that really sets the table for them thinking, we don't just show up in court and automatically get entry. We don't automatically get a result. And pretty quickly, the theme is laid, or a number of themes are laid, including access to justice, that there's a process for all this. And there's a process in this. And all of that, to some degree, is going to cost money. It's going to take resources. It's going to potentially take emotional resources. And it's going to take time. And at each stage of the litigation, and even as we dive into the, more complex doctrines of personal jurisdiction and the constitutional underpinnings of some of our civil justice doctrines, well, what does this do for accessing the courts or not? Does this make it harder to bring your claims? Does it make it easier to bring your claims? Does it make it harder for you to defend against litigation? Does it make it easier for you to defend against litigation? Why and how, and what are the strategic implications of how these doctrines are developing and changing? I sort of end, and I always end my class with a recapitulation of this notion that procedure is power. And often the decisions being made in these cases are procedural, and the cases end before we get to trial. and these procedural consequences and these procedural rules, as you say, that are, you have to read so many of them and maybe memorize them, but they're in service of or at odds with the effectuation of substantive law, the pursuit of justice, the access to the courts. I try to hammer those home pretty much every class or so as they relate to what we're studying.
I love that. I love that answer. Because more than any other course, I think civil procedure is one where students need to see the forest before they start, examining the trees close up, because you talk about the technicalities, the rules, the statutes that students have to learn. There actually is quite a lot of technical detail that they have to master in the course if they're going to understand civil procedure, but they're not going to do that well unless they understand why they should care. And so seeing how it all fits together in the system of justice is essential. And this case file that Maria mentioned, it's 15 pages. It's like I assigned this as it's in the introductory chapter. Students read this before they meet me for the first day of class. And so, it's just a 1 or 2 page abridged complaint and an answer and a little piece of a deposition transcript and a little excerpt from a trial transcript and a little piece of the appeal. And so the students really see, a summary judgment motion. So they see the whole thing in just a kind of snapshot, but it allows the teacher then to get the students to start to care about these steps in the process. So then when you encounter them over the course of the semester, the terrible thing about civil procedure, if it's poorly taught, is that it just feels like a bunch of technicalities, and you're never going to get students to learn well if that's the way they're thinking about it.
Well, I love that contextualization you do from the introductory chapter, that they see all those pieces at the beginning so that later the technicalities fit within those overarching pieces of the puzzle with the case that you've included. Tell me, is that what led you to write a case book in the first place? And we're talking about Civil Procedure by Aspen Publishers, first published in 2020, but now the second edition was out February 2024. What prompted you to write the casebook in the first place? To have some of that contextualization or to use those thresholds of access to justice thinking? Howie?
It's bigger than that. I've been teaching civil procedure a long time. I've taught out a lot of different books, and each of the books I taught out of had virtues. There were things I liked, but none of them was quite good enough. I felt like there were some books that had become bloated with excessive notes and citations and weren't really speaking to 1Ls. I thought that books came from too much of a particular point of view about the civil justice system. And I really didn't find a book that was teaching as well as I wanted the book to teach. And the way I see it, students should be spending 2 hours out of class for every 1 hour in class. And most of that time is with the casebook. So I understand students to be spending more time with the book than they spend with me. And so the book better not be confusing them or just kind of running them around in circles. The book better be doing some real teaching. And so the impetus for the book was wanting to write a book that's sort of like a casebook, and in some ways very much a traditional casebook, but that is more of a teaching text along the lines of texts in lots of other. Imagine an engineering textbook that's trying actually to teach people. So that was the impetus for me. And Aspen had been pitching me on doing a casebook for a number of years. And I just finally, after teaching out of a number of different books, kind of got the bug to do it. And then I thought, okay, but I really want someone else on board for this. And here was this incredible emerging civil procedures scholar, Maria Glover, and a phenomenal writer, a phenomenal thinker about the civil justice system, and frankly, someone who, by virtue of being 20 years younger than I am, comes at it from a kind of generationally different point of view. And lo and behold, she said yes. And she can explain why she thought that was a reasonable decision to make.
Yes, so Howie reaches out, Maria, and what makes you say yes?
Infinite riches. No, I'm kidding.
I'm sure you are.
No, I mean, to Howie's point, one of them was knowing how much students tended to come into class confused or miserable or both, and spending a lot of time clarifying things and not getting into the guts of what's at stake was a real draw. Structuring the course in, I think, a pretty modern way, pretty rational way that situates this not just with the bigger values, but how litigation tends to proceed. At some level, right, you're not going to spend your career as an attorney or even as an academic, if you're in civil procedure, talking about personal jurisdiction. It comes up, but it is not everything. And it's part of the course, and understanding where those sort of older doctrines that have gone all the way back to the beginning of the Republic have evolved through the years and have come right up to very modern cases. You know, we have a case in there about Taylor Swift pursuing emergency relief when people are selling counterfeit merchandise. So that was really appealing to me, to structure this in a way that gave tons of grounding and foundation in the fundamentals, did not lose sight of where the genesis of all of this was, did not short shrift the evolution of law and doctrine, but also brought it to what the modern concerns tend to be, how those evolve, how those play out. That was really attractive as well. And one thing that I've loved in teaching out of this book since we've written it is how much the students tend to come in with a pretty good understanding of those foundations, because it is a case book, but also a teaching text. And so where they leave off with their reading, we're able to run with in class. We're able to dig really deep. We're able to get really into the values. We're able to get really into the strategic implications, in part because the labor of love that was Howie's and my years on this casebook was to ensure that those foundations were really well laid so that the table was set to take those things into the cases now.
Those opening meetings were thrilling. When Maria and I first started talking about the book, and when she was trying to decide whether we had a combined vision for the book that gelled well enough that this was really worth doing, it was what a thrill. I mean, because we spent hours, I mean, tons of emails, tons of phone calls, and then and she's in DC, I'm in New York, but these lengthy meetings where we were in person and just hashing out, okay, you know, the structure of the course. Do we start with this? Do we start with that? Where does this go? What do we emphasize? What are we willing to let go of in order to have a book of manageable size so people can really teach out of it? And, you know, there were compromises in both directions, but mostly what happened was this kind of gelling where, because Maria is such a committed teacher, and frankly, so am I. Like we both think so much about how students experience this course. And so to have those conversations with someone who has thought about it just as carefully as I have, it was really, it's, you know, thinking back, it's, you know, it was a long time, the gestation, you know, as we, you know, conceived this book and tried to bring it into reality.
Well, it sounds like you all had a really good time figuring out how to do it and writing it, and that it's being very well received by students. So what changes did you make in the second edition? What can faculty and students expect from the second edition that's different from the first?
Some of the changes were in response to decisions that have come out, major decisions that have come out, particularly with regard to personal jurisdiction by the Supreme Court. Some of it was tweaking cases that some of our adopters felt would work a little better if we presented them a different way. Some of the changes were finding, for smaller points, some more engaging cases. There are a number of fun fact patterns, actually, in the second edition. One of them involves a gentleman who was selling merchandise from the Augusta National kind of in a black market way. Again, just trying to find ways to engage students. So some of it was just, you know, the yeoman's work of responding to changes in the doctrine, right? There's some major cases that have come out in the Supreme Court, the Ford case and the Mallory case in personal jurisdiction. And some of it reflects that as dedicated of teachers as Howie and I are, we're also dedicated, I think, to the professoriate of civil procedure as well. And we really took to heart thinking through how to make even better what we thought was a great first edition, from some feedback from some really valued colleagues. Howie, I don't know if you have anything to add to that, but those are the major points.
Yeah, the thing about a first edition, or the thing really about any time you teach out of a case and haven't taught out of it multiple times, is sometimes it takes a while before you realize that certain cases are bad teaching cases. They seem good in theory. They address exactly the issue you want to address. But in the first edition, it's a wonderful teaching text. I'm teaching out of the first edition right now because the second one just came out. But there are several cases in there that just don't teach as well as you want them to. And one of the issues when we're finding good teaching cases for a civil procedure book is, on the one hand, you need the cases in a Civ Pro book to cover a huge range of substantive areas. And that's important because you want students to understand deeply the notion of the trans-substantiveness of rules of procedure, so that each time they learn about any aspect of procedure, you want students thinking about how that applies across lots of different substantive areas of law. So it's important that the book include a whole bunch of different substantive areas. But when a case involves some aspect of substantive law, that's just going to be a lot of work for students to understand as a 1L who's never taken that area of law, then it becomes inefficient as a way to teach the procedural topic. For example, in the first edition, we had a case to teach issue preclusion. When teaching issue preclusion, before students are ready to learn about non-mutual issue preclusion, they really first have to master the basic concept of issue preclusion in a mutual text. We had a case that did that very nicely, but it's a bankruptcy case. And to get to the issue preclusion aspect, students had to march up this hill of learning about bankruptcy discharges and non-dischargeable debts. And it seemed like a great case in theory, but actually it just didn't teach that well because it was too much work to get students to understand the bankruptcy aspect. So we found a different case. I mean, that kind of attention to cases and whether they really work for 1Ls is kind of what motivates us.
Great. Well, Maria mentioned the Ford case, the Mallory case, personal jurisdiction decisions out of SCOTUS. What are some of the other, or you can expand on those, significant developments in civil procedure in recent decades?
Okay, I'll start. So personal jurisdiction is huge because, the Supreme Court had like a bee in its bonnet about personal jurisdiction back in the 1980s, and then it was kind of steady for a while. And then all of a sudden in the 2010s, the Supreme Court got really interested again, and that has not abated. And so in recent years, the Bristol-Myers Squibb case, the Ford case, the Mallory case, all fascinating. Then there's pleadings. So pleadings in the 2000s, in 2007, 2009, Supreme Court decided Twombly and Iqbal. That's one of these areas where for my first couple of decades teaching civil procedure, my first decade and a half, I really didn't have to worry that much about pleadings. Notice pleading was kind of straightforward. And then all of a sudden, after Twombly and Iqbal, it got much more interesting and much more challenging to teach. Arbitration. You can't teach civil procedure now and not make sure your students, it's not a course on arbitration, nor is it a course on mediation and negotiation, but you can't teach civil procedure in 2024 and not have students understand that there is this entire world of private dispute resolution that looks like litigation. That is arbitration and the ways that intersects with litigation. And you can't teach now without making sure students are thinking about settlement dynamics all along the way. And then, of course, the world of mass litigation, class actions, multi-district litigation, that's been a fast-changing area as well.
I would agree with all of those and just add to it, sort of overlaying with it. You can't teach civil procedure in 2024 without accounting for the vast growth of contracting for procedure, contracting either around or out of the default procedural rules that you learn in, the procedural course, contracting even around some of the doctrines that they're learning with venue and which law applies, even understanding that procedure dictates in large part which substantive law is going to apply. So one thing I would add to that, again, it's exactly the list I would have given. I would just add to that, and it's not a course on contract, but I think students do like thinking about the intersection between what they're learning in contracts and the fact that, oh, wow, we can also, with great latitude, contract for the dispute resolution procedures themselves. And thinking about how that interacts with everything they've learned is a really big point to make in a modern course.
Well, you both have scholarship that focuses on class actions, multi-district litigation, mass torts. And so I wondered, this is such a huge growth area in civil procedure. How much of that should be covered in the 1L civil procedure course? Do you have any views on that?
This is one of the things I found most frustrating about other books, is that often civil procedure books have units on complex litigation, on class actions and such, that cover so many pages that nobody can really assign that. And I mean, if you're blessed with 5 or 6 credits for teaching civil procedure, then maybe you can. But for most of us who have 4 credits, or in some cases even less, to teach civil procedure, and who are doing it in one semester, you can't devote multiple days to class actions and complex litigation. Frankly, there's too much other stuff that's important for students to learn in the civil procedure course. What a shame if teachers therefore decide, oh, I guess I can't cover class actions, I'll just skip that topic. Because it feels like educational malpractice to teach civil procedure in a world where so much actual civil litigation is in the world of mass litigation, class actions, multi-district litigation, mass disputes. That's so much of the real world of civil justice practice that can't not teach it. And so even though this was very painful, I mean, Maria Glover is one of the great scholars of complex litigation in the country. And frankly, I'm no slouch either in that regard. That's kind of been the main area of my own scholarship. And so it would have been so much fun to write a 300-page chapter on class actions and multi-district litigation. And we would have fought over who gets to focus on that chapter because we'd both want to do it. But we resisted that urge and instead created a unit on class actions and MDL that can be taught in a single 2-hour class session. And it works. And I think for civil procedure teachers, you have to resist the urge to turn the 1L course into an advanced entire course on complex litigation. That's why we offer an advanced course for the people who want to specialize in it. But really, every student should learn what class actions are, should learn the fundamentals of class certification, should learn the fundamentals of class settlement approval, and should learn the fundamental issues about how class actions can help access to justice and where the problematic areas are, where class actions can go awry. And every student should learn about multi-district litigation. And they should learn about it not just as a weird twist on venue transfer, but they should learn about it as a very important type of aggregation mechanism. So we're actually pretty proud of sort of how that came out in the book, even though it was, I admit, painful to keep it as short as we did.
To echo the commitment to keeping it short is also, for me, the ways in which aggregate litigation isn't just something you have to teach in civil procedure because of its outsized role in the civil justice system. It's because there are important through lines to the chestnut civil procedure cases between aggregate litigation and those cases, right? Twombly is a class action. Justice Souter's concerns about letting things go to discovery after a motion to dismiss arise in the context that he explicitly talks about, which is a complicated, expensive antitrust action. Bristol-Myers Squibb, one of the newer personal jurisdiction cases, stems in part from the Supreme Court's concern about nationwide class actions where some people to the litigation who are plaintiffs are disconnected from the state in which the suit is brought. And so perhaps ironically, but maybe not, we try to make it a manageable package, not because there isn't more to say. And again, there's these upper level courses that we teach and the scholarship that we write about that we believe it's very important to expand your knowledge, but we did not want to risk it getting left out from the civil procedure course. And so we endeavor to make a package that worked inside a 4-credit civil procedure course because it's so necessary, again, not just as a matter of its role in the civil justice system, but because it is directly connected to so many cases in civil procedure and so many questions in civil procedure that are operating both in the foreground and the background.
Well, thank you. And I appreciate your sharing not only the decisions you made regarding what to put in the book, but also, how you approached the material to make it more accessible to students in civil procedure by Aspen Publishers' second edition, which has come out in February of 2024. Before we conclude, I wanted to ask each of you to answer my final question for all my guests, and that is, what are your predictions regarding the future of legal education in the coming decade?
Ooh-wee, the future of legal education. Well, so when I think about the future of legal education, I think about the future of lawyering, and therefore I think about artificial intelligence and technology and the sorts of things, and I think about the things that with the benefits of technology, the things that non-lawyers can do that people used to depend upon lawyers to do. And there's a temptation then to think, okay, the world is changing so fast, surely legal education will have to change just as fast. But I don't believe that. I actually think the fundamentals of legal education work reasonably well for the future there. So what's not going to change is that there are a lot of laws that govern the way people do things and the way businesses do things. And what's not going to change is that people and entities interact in a way that has legal implications and that can give rise to disputes. What does change is the way you don't necessarily need a human lawyer. So the question I always think about is, what is it that a human lawyer offers? At least for the coming decades, what's the sort of thing that a human lawyer really offers? Because what I want law schools to do is educate human beings to be human lawyers who actually have something useful to offer. And it seems to me on that, you need to educate people to have judgment, to have deep understanding of legal issues, to be able to develop client relationships and to see clients as people or entities with problems that need solving. And actually to do that, you need quite a lot of legal knowledge, not knowledge of every, of whether this is 30 days or 21 days in this rule. Obviously, technology can deal with that, and you can always look things up and research them. But you need knowledge of lots of different areas, including civil procedure, so that you understand the architecture of law. And so you have a framework for even thinking about how to address client problems. And I actually think in-person law schools with 3 years of legal education and some combination of doctrinal education and experiential education, I think that's really well suited to do the sort of thing I'm talking about. So I'm looking forward to continuing to do that.
One prediction I have is that, and this is already happening to some degree, but law education, or legal education rather, I think will, especially in the upper years, focus increasingly on larger disputes and disputes that don't confine themselves neatly to the United States borders. That, far from taking emphasis off United States architecture or the sorts of things we talk about in the civil procedure course, I think actually reinforces the need for it. Not necessarily because what rules we pick are the best rules or the only rules, but because they may not be the best rules. They may not be the only rules, and they're not the only sets of architectures which are going to have to interact. And comparing those different architectures is an experiential matter because you have to be able to navigate them in the disputes, also drills down to the more fundamental questions that I think legal education is asking, and why the foundations, is how we said, I think are pretty sound, because we are asking a lot of the same foundational questions now or 20 years from now when AI is taking care of some of the more technical tasks, which is, what is a right? What are the duties of ourselves to one another? What are the duties the government has to us? What are our responsibilities in a civil society? How do we order ourselves? How do we achieve justice? What is justice? What is the process for keeping order and keeping justice and remedying rights and enforcing duties? And that's something that a lot of societies are grappling with. And the fact that you have to navigate them in an intersectional way, I think, is something that's going to evolve in legal education, and at the same time, reinforce the foundations of what students are learning now.
Thank you both so much for those really thorough answers. And we'll see, right? Every day it seems like something new is happening in legal education, but in many ways we stay the same. Thank you, Professor Erichson and Professor Glover, for talking about the second edition of your civil procedure book by Aspen Publishing and about your approach to teaching civil procedure in law school. And for those who are listening, if you'd like to listen to additional episodes of Aspen Leading Edge, you can find it on the Aspen Leading Edge podcast webpage or on any of the channels where you find your other favorite podcasts. Thank you both so much.
Thank you.
Thank you for having us.